The government agency I am going to be presenting on is the National Labor Relations Board. The National Labor Relations Board, also known as the NLRB, was started by the National Labor Relations Act, abbreviated by NLRA. It was signed into law by President Franklin D. Roosevelt in 1935. The Act protects workers from unfair practices by employers that attempt to bar employees from organizing unions and collective bargaining agreements. It is the responsibility of the National Labor Relations Board to regulate and enforce the NLRA. This includes helping employees organize, structure, and develop representation for groups to help gain better privileges and treatment in the workplace. The NLRB also helps adjudicate claims brought to the court where employees or employers feel they have been treated unjustly according to the laws laid out in the Labor Act. As stated before, the National Labor Relations Board was developed in 1935 as the National Labor Relations Act was passed. The Act was passed in order to create regulation in relationships between employers and employees within the private sector. Post-industrialization and mid-depression within the United States, union strikes and riots were commonplace in metropolitan areas. Poor working conditions, unfair labor practices, and adversarial relationships between employers and employees led to the creation of the NLRB. Employers at this time were known to disband and deny any attempts at creating unions for workers within their trade or industry. The board was put in place to mediate between the employer and employee. It also helped develop and process union organization, as well as serve as an adjudicator for cases brought to the government because of the injustices stated above. A business would find the NLRB knocking on its doors for three different reasons. The first being an employee or group of employees feels the business is treating them unfairly in regard to interaction between the two parties. Relationships between employers and unions can sometimes be hostile. Unions organize and give employees a voice when speaking out to an employer over an issue that they disagree on. The NLRB works with both groups in lawsuits, hoping to work out a settlement that the claim will never actually reach court. When a settlement isn't agreed upon, the NLRB adjudicates on the case between the union and the employer. Prevailing wages is also another reason why the NLRB would be present within a business. Prevailing wages are the regular cost per hour for an employee within a geographical area. The settling of these situations helps create a more positive job bidding environment for companies that come into this certain geographical area from another place, such as a different state, that offers a lower wage versus a higher wage within this select geographical area. An employer probably, as well as an employee, hopes that they never have to seek help from the NLRB unless an unfair practice is occurring. So interaction is usually infrequent, but extremely important and sensitive when it does occur. In February of 2014, college players at the University of Northwestern of Chicago appeared to the NLRB that their performance in athletics was being profited by the university. The players argued that they were not getting fair compensation for the actions, being that the university was gaining millions of dollars from their performance in athletics. The university responded that they were student athletes and not employees. The NLRB ruled in favor of the student athlete, and right away, the University of Northwestern appealed to a higher NLRB court in Washington, D.C. As of today, the appeal has not been adjudicated on, and the whole situation is still in question. These are my sources. I researched the NLRB on their own website, the National Labor Relations Board. I got information from there on the history and the responsibilities of the National Labor Relations Board. I also interviewed my dad, Dr. Eric Hoekstra. He was the head of the HR division of Harbor Group. He also worked on their board of directors and served in the HR position. Harbor Group is a holding company of Interstates Companies, which is a nationally known electrical, engineering, and construction company. So they dealt a few times with the National Labor Relations Board and the work that they did with electricians around the country. He shared his own personal insight into prevailing wages and also experiences that he dealt with in two different NLRB claims from employees in companies that Interstates contracted with during his time at Interstates Companies and Harbor Group.